Hello and welcome again. Recent videos, specifically numbers 31 and 32, have spoken about torts and liens, and in doing so have touched upon the topic of common law. The latest video, number 34, expanded briefly on the relationship between common law and statute or codified law. But what of the relationship between common law and Article 61? We must first define common law and why it exists and how it is administered. As already stated, if everyone behaves according to universally accepted standards of morality, there is no need for laws to be written down or enacted by legislation. Our consciences, motivated by such teachings as the Golden Rule and our everyday experiences of life, give us a virtually foolproof guide as to how to conduct ourselves in our dealings with others. Looking a little deeper into the subject, we see that whenever someone departs from this universal moral code, they do so by committing a definable offence against another individual. Even if there are many victims of an action, such as in a bank robbery, a widespread fraud, or what Australians commonly refer to as a rort, or even a mass murder, each victim has the right under common law to individual assessment and the application of justice. This contrasts markedly with the alleged application of justice exercised by the legalese system under statutory law, where the individual's rights are often completely ignored by classifying the offence as being against the interests of the Crown, with penalties such as jailing, failing to offer any recompense to the victims, or fines becoming revenue which accrues to benefit those administering this corrupt system. A definable offence, it should be said, in passing, does not consist of a mere difference of opinion. As long as no physical or measurable damage or harm has occurred or is incited, each person is free to express their own opinions on any topic. Under common law, the primary aim is to establish the intention to cause harm or loss, commit fraud or violate the peace. If malicious intent is established by the jurors by unanimous decision, then the juror's role is to decide upon the recompense required to restore the integrity of the aggrieved, while deciding on a proportional compensation and consequences for the accused that would minimise the level of latent resentment and animosity on the part of the accused, facilitating the accused willingly atoning for their past with future behaviour. This is unlike the extreme punitive judgments made by the unaccountable criminal corporate courts that are geared towards the escalation and entrenchment of past behaviours. Should the jury fail to establish the existence of malicious intent on behalf of the accused towards the aggrieved, then their role is to come to an amicable solution that restores the integrity of the aggrieved while also preserving the integrity of the accused. This is where the principle of tort law enters the picture, or rather first entered the picture several thousand years ago. Common law attempts to provide atonement or reconciliation between the individuals involved, and this principle extends into every household, so entrenched is it in the minds of community members. This is obviously best done between the individuals concerned, without having the matters hauled into court, where under the current dysfunctional regime, there are numerous opportunities for miscarriages of justice, mainly because the administrators of the system have sectional and prejudicial interests. Those purporting to be government demand funding. The police and the practitioners of the legalese system all have their own axes to grind, which all too often leave the victims more aggrieved by the judgments of men and women acting as judges and magistrates. Those who seek to go into the fake courts and obtain remedies by resorting to common law are frequently unaware that much of the principles they seek to use have been devised and placed in the legalese system as traps. Occasionally there is a victory, but as stated previously, the long-term result is that the corrupt system remains intact and capable of being manipulated in future to undo the temporary benefits obtained. Stick to Article 61 and the simple principles of common law, which are that authority claimed must be established before we engage with it. The depth and duration of the deception practiced by those operating the legalese or statutory codification of law is truly staggering to most people. For instance, in the case of Australia, which was first colonised by Britain in 1788, the claim was made that this was a land classifiable under the Latin phrase terra nullius, meaning effectively unoccupied by anything or group that could be accorded recognition as a civilization. Of course, those living here at the time had their own laws and customs, accorded recognition and legitimacy by each group or tribe. But these were not written down, so the colonisers dismissed them as of no efficacy. Documents have now been brought to light which indicate, at least as early as 1838, that plans were afoot among those elites we already mentioned to maintain Australia as a colony in perpetuity, disguising the fact by encouraging or allowing the eventual provision of a so-called constitution, ostensibly granting some form of independence, but in reality subjecting the inhabitants to a dictatorship of Parliament, in much the same manner as had been attempted and virtually accomplished in Britain with the infamous Bill of Rights of 1688-89. It's respectfully suggested here that to engage with any system capable of such Machiavellian, even satanic malevolence, is to dance on a precipice with woeful naivety. It must surely be called out at every opportunity and denied every instance of assertion of its false authority, and Article 61 is our Arthurian sword for this battle. In an average household, it is safe to assume that we won't find an extensive list of rules or laws to which all must adhere pasted upon a wall or even listed in books on a shelf. Everyone knows from their conscience how they ought to behave towards the other members, even if they are not in a familial relationship. There may be short lists, often humorous in design, which refer to the execution of household chores or the preservation of niceties regarding bathroom protocols, etc. But the common laws regarding acceptable behaviour within and without the dwelling are almost invariably absent. When those universally known laws are broken or breached, the common law system stands ready to preserve or restore the right by means of trial by jury and annulment by jury of unjust legislation, which does not treat everyone equally or preserve their natural born rather than their artificially granted rights. Such concepts formed the basis for the devising and sealing of the Magna Carta in 1215. King John and all subsequent monarchs were placed under the obligation of obeying the common law along with all other people. Sadly, like King John, we are all afflicted with personal foibles and weaknesses, and occasionally give offence to our fellows, even though these offences may be the result of accident or thoughtlessness rather than intent. Though thankfully for the community, few exercise these personal flaws with the intensity displayed by John. However, when such things happen, it is only right that some attempt to rectify those wrongs is undertaken. And this brings into play another concept, without which it is extremely difficult, even impossible, to construct or maintain a harmonious, peaceful community. I refer, of course, to the principles of forgiveness, reconciliation, or atonement. Atonement is an interesting word. Broken into its 3 syllables, it reads as at-one-ment, a subtle difference from the more widely considered application of punishment for some wrong. Article 61 provides not just an opportunity to punish the monarch for treason, but also proffers a time frame for redressing of the issues. It also specifically states that when the treason is redressed, the people shall resume their former relations with us. Were this provision not present, what would be the point of requiring the monarch to repent of their errors? Indeed, why would anyone rectify any errors if the situation of estrangement were to remain in perpetuity? This is perhaps the most vital component of common law, that people, when once having had their errors explained, be entitled to expect reconciliation and atonement if they mend their ways. In some cases, not referring to Article 61 here, where definite changes in action must occur, an apology may be all that is necessary if malicious intent and a definable harm has not occurred, and it is only our emotions or pride that have been disturbed. Thus, like all good and sound principles, these aspects of the common law apply in both the material and the spiritual realms of human interaction. All truth is indeed part of one great whole. Another word mentioned is forgiveness. Again, an interesting one. Its literal meaning is to give something before the event. In this case, credit to those who have offended us that they will honour their commitment to refrain from doing so again, at least in the selfsame manner. When we forgive, as in the case of a judgment in a common law trial by jury, we accept the principle that the offender is making whatever recompense they can, and we agree to re-include them in the community on the former basis, as if they had not offended in the first place. We do this because we know that one day it could be us that makes a mistake, and we hope that we would be accorded the same courtesy and grace if repentant. Without this principle, community and indeed family life would be one unending round of recrimination and resentment. Common law exists to restore the harmony that normally applies in the most practical way, given that human beings will always make mistakes and commit occasional offences. By espousing and committing to Article 61, we work towards restoring common and natural law, which is the gentlest and or least tyrannical form of law, and encouraging people to treat each other with compassion, cooperation, and love. To be consistent, these qualities need to be applied in all aspects of our lives. Regarding those whose unlawful demands we are resisting, it is these that we hope to rehabilitate by means of education, as is stressed repeatedly in the notices. We accept that initially they may be unaware, because of the deception of their bosses, of the seriousness of their offences. But we stress that having been formally notified, they may no longer plead ignorance as an excuse. The commitment and effort to educate is really a labour of love, the opposite of which is not hatred but indifference. If we can succeed in this endeavour, we not only rescue those people, but provide a way for them to rescue and preserve their own descendants from the traps prepared for us all. Those who will not hearken to the law once they know of it, of course, deserve whatever consequences befall them. When first we spoke of Article 61 and our oaths to the barons, etc., we explained the meaning of the symbols on the shield, some of which relate to the principles of Christianity, which form the basis of our common law, and have made possible the restoration of ordered, generally peaceful and prosperous societies even after the most horrendous and destructive wars of the early 20th century. I urge everyone to seek rapprochement with as many people as possible, even those we now regard as enemies, and in so doing, we will advance the cause of common law harmony and the restoration of the rule of law devised under Article 61 to a much greater effect than we imagined. Some may regard that as a touch idealistic. But is it not a fact that if everyone now living had a better relationship with everyone that they know, the world would be a happier place? None of us can realistically hope to change the entire world, but we can change that little piece of it that we each occupy. Thank you for watching.